watching the award-winning GHS-TV, a nationally recognized student television station.
Welcome to Let's Talk Business. My name is Kelly Bolton, and thank you for tuning in as we have the distinct pleasure of hosting our community's foremost leaders, entrepreneurs, and civic heroes. In life, two things are certain: death and taxes. In addition to paying taxes throughout your lifetime, we may even have to pay taxes upon our death. We would much rather pass our wealth to our loved ones rather than to the government. Today, we're going to discuss the many ways available to help you in this area. Joining us in this discussion, we are thrilled to have with us Blanchard Toole, attorney with Toole Graves Law Firm. Blanchard, thank you so much for joining us. I appreciate you being willing to do this in this very unique setting in this coronavirus world that we're living in. But I thank you, and your reputation is phenomenal. And to be able to have you on the show, I thought maybe we would start with, maybe you could explain to our viewers, what does an estate planning attorney do?
Well, an estate planning attorney looks at the assets people have, at their loved ones, their husbands or wives, their children, and how they want to use those funds to provide for their spouses and their children at death. There's four really main components of every estate plan. One is the will or a revocable living trust, and the other three very important documents are living wills, where you make two decisions: one, if you want to be an organ donor, and then two, to give your spouse or someone else the authority to withhold nourishment if your attending physician has ever said that you're not going to survive. And then the two other critical documents are durable powers of attorney for finance and health care.
And that's very important. Well, then who needs an estate plan? Does everybody need an estate plan?
Everybody needs durable powers of attorney for finance and health care. When my children turned 18, I had them sign those documents, and I've gotten so over the last several years where I've talked to my clients into having their college freshmen come by my office and sign durable powers before they go away to school. Everybody needs to have a durable power of attorney for finance and health care. The costs, both financial and emotional, are horrendous if everybody does not have those documents.
You know, that's very interesting, Blanchard. I think in all of my years of practicing in the financial industry, this is the first time I've really actually had that discussion with somebody about the importance of, at 18 years of age, you need something, because they may have a credit card bill, they may have a checking account, they may have something, and I guess just because you're their parent, you don't have a right to go in and handle it.
You know, Kelly, that's a huge misconception that people have, especially when you're talking about college kids. You may be paying for their education and their tuition, but if they're over 18 years of age and they're at a college or university and they have a traumatic injury, the hospitals and the doctors are not going to deal with the parents unless there's a durable power of attorney or unless there's a conservatorship granted. And to have to go through the conservatorship process is enormous expenses, and I can outline for you exactly what the costs are going to be, but it can easily be $10,000, $15,000, $20,000 by the time you're through.
At a time that
simple, durable power of attorney for health care bypasses all of that.
That's really interesting, and the same thing goes, I guess, you know, it was caught me by surprise thinking of an 18-year-old, because you don't think of it, you know, how important that would be. But I guess the same advice would go to, as you said, anyone, because if you have a traumatic event and somebody you love is in the hospital and you go in to try to make a decision or to pay their bills or, handle something, the last thing you want to do is be getting on the phone with an attorney and saying, I need your help.
Well, in so many, in today's world where so many people are living together, and then say you've lived with someone for 10 years and you don't have a durable power for health care, and then you have an accident, and so you have the other your other live-in call and say, I need to make medical decisions, and they say, well, are you a spouse? No, which automatically creates an aura of suspicion from the hospital or the doctor, because they say, well, they're not married. We're going to give this person the right to make medical decisions. They won't do it. So the only option, if you don't have that, is to go to probate court to get the authority. And that's where you get lawyers involved, and time and money and expense and bond premiums and accounting. And it's a nightmare that could all be taken care of by having a simple 2 or 3 page document.
It's very interesting, and I think that's important to note for our viewers, is that you don't have to be a wealthy person to need those things, because we all have health matters and financial matters. And you mentioned a will versus a living trust, and I'm very familiar with it, but obviously not to the extent that you are. But what is the difference, and when would you advise one versus the other?
Well, it depends on everyone's different financial and family situation that they have. But, I've always taken the approach that I want to keep my clients away from probate court. Why? One, I don't want them to have their document made a matter of public record. 2, I like the idea of it being private. 3, I don't want my clients to have to pay attorney fees and court costs to go to court and have the matter tied up in a probate court where a judge is making decisions for you rather than your own family members. If you have a will, it doesn't necessarily have to be probated, but if that will leaves any assets to any individuals and those assets are in the decedent's name, then you're going to have to probate the will in order to transfer title to the assets. If you have what's known as a revocable living trust, then that bypasses the probate system and allows the successor trustee to take over immediately. Now, a revocable trust is more on the front end because the lawyer is going to be required to do more, but you save more on the back end, not only in fees and expenses, but in the, as I said, the privacy and not having the expense of go to court and deal with lawyers.
Yeah, that makes a lot of sense. And, I would say most people are private when it comes to their financial matters, and would prefer for it not to be a matter of public record. And also, I know in my experiences, when you've lost a loved one, the pain and suffering you're going through is enough to have to spread it out over a period of time and pay a lot of money and all the costs that get associated with that. I know that's very hard. So that's very interesting. It looks like we need to pause for a short commercial break, so please stick around.
GHS-TV started in 1982, and it was just a couple of cameras, a couple of on-air personality, and it's really grown into what you see today. It's a multi-million-dollar studio with top-of-the-line technology.
Being able to operate, all of the machinery in the control room, being able to use all of our software and hardware that we have around the studio is a great skill, because this is top-of-the-line equipment.
I feel like this class has brightened my horizon. It's something that I never thought I would be doing, especially as a student.
GHS-TV is probably one of the most hands-on experiences a student will ever get in their lifetime.
Welcome back to Crosstalk. Nothing really has just the vibe that we have here.
Especially after you finish, you get a real rush of, wow, I just did that.
By the time a student graduates from Germantown High School, they will know pretty much every position there is, from producing to directing to on-air work.
You learn time management, you learn organization, you learn how to work with people, how to better communicate with people.
We put a lot on them, and they have to be able to have the responsibility and the knowledge to get everything that we ask them.
I had very little experience, so in the past 3 years, the skills that I've learned have absolutely exponentially grown.
The class has actually helped me figure out that I want to go to college for journalism.
When a student graduates, they are the best possible version of themselves that they can be.
Thanks for tuning in. We'll see you tomorrow.
For more information about the Kappa program, visit ghskappa.com or call 755-7775. watching the award-winning GHS-TV, a nationally recognized student television station.
Welcome back to Let's Talk Business. If you're just tuning in, I'm Kelly Bolton, and today we've been discussing the importance of estate planning. To continue this discussion, we've invited back estate planning attorney Blanchard Toole. Blanchard, thank you for sticking around for our second segment, and we're going to have 3 segments, and we probably need about 3 days worth of segments so that I can get all my questions in. But I mean, hopefully you've convinced everybody. There's no doubt everybody needs a will. Everybody needs, you know, at least powers of attorney for health care, living wills, that sort of thing. And we talked about privacy, which is important, but let's talk about cost. A lot of people have heard that you can pass a lot more money now on to heirs free of taxes. But does that negate the need for a will? Just because you can pass more?
You have to have a will or a trust or a testamentary document in order to transfer the assets to those you love, whether it's a surviving spouse or to children or to grandchildren or to charity. So if you don't have those documents in place when you die, then the laws of intestacy, and that means if you die without a will, take over, and then you don't control where your money goes, the state does. And normally it goes to either spouse or children or a combination of same. So, you know, you really need to have testamentary documents in place before something does happen so that you decide exactly how you want your assets to go and not somebody else.
Well, and that's important. And it doesn't matter what size estate you have, correct?
No, it can be several $1,000s to several $1 million. And if you don't plan and have it in writing, then it's going to be a problem. Well, I've had many a person come to me after their father or mother died, and they say, well, he or she wanted me to have this. And I always say to them, if he or she had wanted that, they would have put it in writing in a will or in a trust.
Right. Well, and I know in current times, there's a very high limit on what you can pass free of taxes to someone else. What is that dollar amount that is currently there?
Well, it's interesting that you asked that question now, right after allegedly President-elect Biden is going to take office. You know, over the last several years, we've really had in this country what I call the golden age of estate planning. I've been practicing law over 50 years, and we've never had high exemption, lifetime exemptions and death exemptions that we have now of currently 11.5 million per person, a total of 23 million for a couple, with a maximum rate of no more than 40%. We've never had that before in this country. Whether we're going to go back to something a lot lower than that next year, I would say probably. How much, we don't know. President-elect Biden now has said during the campaign that if he were to win and the Democrats had control of the Senate, that he would like to see the exemption go back to 5 million a person from 11.5 million per person. Bernie Sanders wants to take it back to 3.5 million per person, and he wants the rates to go up to 77%, which is where they were, you know, back in World War II. So it's going to be an interesting dynamic this next year to see where the estate taxes go, but it's almost certainly going to go lower. But let me point this out, Kelly, because this is a question a lot of people are asking, especially now that we think that it appears as if Vice President Biden is going to be the president, is what about the rest of 2020? And the answer is that right now through December 31st, 2020, the exemption is 11.5 million per person. And the IRS has let it be known through regs that they are not going to what's called claw back the money if you go on and give it by the end of the year. So people that have significant estates, if they give their total of 11.5 million and they give it to their children, to their grandchildren, whether in trust or outright, then even if the law does change in 2021, those gifts will be okay and will be complied with by the IRS.
Very interesting. So those are some things to consider. And, you know, our show that we're currently filming today will start showing soon. And then they may even be showing this show into 2021. So our viewers will get to hear us have this conversation about 2020 and what we're thinking might happen. And then they can maybe look back and see. And so it's very interesting, you know, what you're saying. When you're talking about a will, versus a living trust. A living trust, we know, does not have to go through probate, and it's not public. A will is probated, and it is public. And what is the cost of probate, and what is the downside of probate?
As I stated earlier, the first downside are the fees, because, you know, you'll have to pay a lawyer to meet with the client, go over the will, prepare a petition to probate the will. Of course, now with COVID, you know, we're doing everything remotely, but at least before then, you know, you have to meet with your clients, go to court. Then the lawyer would have to at least go to court one more time in order to close the estate. You know, you may have to file a annual accounting. You may have to file a final accounting. If the will didn't waive bond, the personal representative might have to post a bond. And again, the attorney fees and the court costs aren't that bad. You're looking at $300 to $400 over a year and a half administration. But you know, I just don't want my clients to have to pay, even if it's me, to pay lawyers to have to go to court if you don't have to do it.
Now, that's very admirable of you, Blanchard. That's one of the reasons I asked you to be on the show, because you always seem to have the client's interest first. And
you know, if you do what's right for the client over the long term, and it's always right not to go to court, then most lawyers, we all got plenty to do. It's, you know, we're not going to miss a meal because we have to take a client to court to do their will. So why not do the right thing and say, you don't need to do it, and don't pay me this money to do this. Pay me the money to do something else, but not this.
Mm-hmm. Well, that makes a lot of sense. I really appreciate that. Looks like we need to pause for another short break. So please stick around as we continue our discussion on how to protect your family and wealth.
And it's very fun to be in band, trust me. So much fun.
When I was an 8th grader and I saw them march, and I was like, wow, I need to be a part of this.
Our main performing group is the varsity band. That encompasses our marching band and our varsity concert band. We also have the jazz ensemble.
It's unique, so we're really lucky to have that.
I'm very methodical about teaching. I try to stay up to date because I want my students to have the best information that I can pass along to them.
He's excellent. He commands a sort of drive that we didn't exactly have.
I lead the class, but I also believe in the students self-assessing their work.
The leadership is led by the students. We lead most of the practices. It's basically just student-led.
And I think that's important for them to take that kind of ownership.
If you want to be a musician, you gain extremely important music skills, music techniques.
1, 2, 3.
There's so many opportunities for fellowship, and band is a family. And you develop that small community where you support each other, not only musically, but in many ways.
Really, without the band, the football games would be lame. Without the band, you wouldn't really have the pep rallies. The band is like a good foundation for the school spirit. If you want to join band, just do it.
I think band was the best part of my high school career.
For more information about the Kappa program, visit ghskappa.com or call 755-7775. You're watching the award-winning GHS-TV, a nationally recognized student television station.
Thank you for joining us on Let's Talk Business. I'm your host, Kelly Bolton, and today we've been discussing the tremendous impact taxes can have upon us, even at death. Joining us on this very important subject is Blanchard Toole, an attorney with Toole Graves Law Firm. Blanchard, thank you for doing this show, and I'm certain that we're going to have you back again because I've got a lot more questions. But I understand about wills, and I understand living trust. And you shared with our viewers that, but there's also joint living trust. And can you tell us the difference between like a living trust and a joint living trust?
Yeah, and I'll tell you why over the past few years that I've gotten to really use joint revocable trusts a lot, and why I like them. If you do a revocable trust, then the spouse, the husband can do a trust, the wife can do a trust. By having a joint revocable trust, you can just create one document, have all the assets go in one trust, and then at the first death, then you have what's known as a survivor's trust that lives off all the assets. And then after the survivor's death, then the balance goes to the children. The thing I like about joint revocable trusts are it's in the long term, it's less expensive because you don't have to worry about, for example, the husband dying first, he leaves the assets to the wife, then the wife has to prepare her own estate planning document or amend it in order to deal with his assets. If you put all the assets in one trust at one time, you don't have to do it again. Another advantage that I've seen is that, in today's world of blended marriages, people are living longer. There's not the stigma to divorce that there was years ago. So I'll meet with 10 couples and maybe one or two will be first marriage, his children or her children. So when you're dealing with blended marriages, I like to be able to control the assets in one trust so that each spouse knows that at the first death, that trust becomes irrevocable. And if she's got 2 children of a first marriage and he's got 2 children of a first marriage, that whoever dies first dies with the assurance that at some point those assets are going to be distributed equally to the 4 children, using my example, where it's a lot harder for the surviving spouse to not do what they agreed to when both of them were living.
That's interesting.
The other real advantage to revocable living trusts is, and I've seen this a lot the last couple of years, especially as I've done wills for clients in their 60s, 70s, and 80s, where one of them is starting to have early dementia or Alzheimer's. And so you want to go on and prepare a joint revocable trust so that if the healthy one dies first, that you've got a son or a daughter or somebody else that'll serve as a co-trustee or maybe sole trustee for the one who's got dementia. And again, you're doing that to protect the one who has dementia from not having to worry about transferring the assets to a testamentary document once the husband or the wife dies.
That's a really interesting point, Blanchard, and I'd love to continue that discussion with you sometime when we get back to normal, maybe over lunch or something, but that's a really interesting concept because just like you, I see a lot of second marriages or third marriages or whatever, how many marriages they are, but that is a real concern, and I've seen many times this agreement, and there's no intention to deceive, but spouse one dies, they both do a will, they've got money going to children from both marriages, but this spouse dies, and spouse A dies, spouse B gets the money. And then a few years down the road, 5, 10 years, maybe they've gotten older, maybe they've started to lose a little bit of some of their mental facilities, but certainly not incompetent, or maybe they remarry and they go to an attorney that's not, that has no ill intention, but says, what would you like to do? And the person says, I'd like to leave the money to my children. Well, that's children by birth, not children by what I had with the second marriage, even though those children may have been raised by spouse B. And I've seen before where someone unintentionally disinherits people that was an agreement between them and a previous spouse, and unintentionally then leaves money at their death to the new spouse. So I think that concept is really, really a very good concept, and I like the way that works.
It protects everybody, and I always have a husband and a wife do a contract to make a will where they both say that at the second death, that the assets will be divided among their respective children. But a lot of times when the first spouse dies, the second spouse, will not honor that contract. Now, I've never had a problem with it with my clients, but I've had a lot of cases come in where the surviving spouse was trying to get around not giving the assets to the deceased spouse, children that were only his children and not her children.
Mm-hmm. Yes, I have seen the same thing, and there's nothing worse than when you've got the death of someone and then you've got the fighting and the conflict that deals with, that comes from, arguing about money. Well, in this particular case, when you have an issue where there's something being contested, or you have an issue of just handling things because someone becomes incompetent, like you mentioned, a son or a daughter being co-trustee. What is a trustee, and what is the role of a trustee? Can they do anything they want?
Well, I mean, the trustee has legal title to the assets, but is for the benefit of the beneficiaries, whether it's the surviving spouse or the children. So I always tell people, when you name a trustee, you're giving that trustee the authority to make decisions that you would probably make if you were here. And you want the trustee to have good judgment. You want them to be honest. You want them to be diligent. And you want them to do what they probably would have done had they lived. When I've served as trustees, I bought numerous cars for teenagers, for 20-year-olds, for 25-year-olds. I bought homes. I paid for vacation trips. And it's all a matter of discretion. And in the trust that I draft, I always say that I give my trustee the discretion to provide for the beneficiaries for their support, maintenance, education, and welfare. And you're trusting that trustee to do what he thinks is appropriate at the time that he's asked for it or she's asked for it. It's a big responsibility.
It is a big responsibility, and I wish we had a lot more time. I thank you very much.
Happy to be here.
Once again, we would like to thank Blanchard Toole for being with us today. Like the saying goes, there are two things certain in life: death and taxes. Hopefully this show will help you at least avoid some taxes at death. If you have any questions about today's topic, you can reach out to Blanchard Toole at 901-474-1222. That's 901-474-1222. You can also check out our website at GHS-TV.org. I hope you've enjoyed our discussion, and I hope you will join us again next month on Let's Talk Business.